Awesome. So everybody's getting into the room. Hi, everyone.
Good morning.
Good morning. Good morning, everyone.
Morning.
All right. Thank you so much for joining us. Kia ora koutou and welcome to today's session from the Hawke's Bay Chamber of Commerce Business Insight Series. Really happy that you could join us today. I'm Jessica. I'm the event manager for the Chamber. Just to start off, please be aware, everyone, that this webinar is being recorded and it will be available on the Chamber website for rewatching. Today's topic is our business insights, what's on the radar for 2026, staying ahead of change. And it's an important issue for all employers in light of some recent developments and what's going to be coming up in the next few months or so. We're joined by Myriam Mitchell, partner at Ashcroft Mitchell McGregor. Myriam has over 18 years of experience in employment and health and safety and dispute resolution. She provides practical, legal, grounded advice to businesses across New Zealand. So during her presentation, she's more than happy for if you need clarification or if you have any question about the particular topic that she is talking about in the moment, please feel free at a pause to say that you've got a question. You can always use the hand up button, or you can also put your questions into the chat. I will be monitoring all of that to make sure that nothing gets missed. And then also at the end of the webinar, we'll also open the floor to questions in case anything comes up while you're having to think about things. Again, feel free to put stuff in the chat and I will read those out if you don't feel comfortable doing that or you don't want to. And yeah, without any further ado, I'll hand it over to Myriam.
Great. Thank you, Jessica, and good morning and welcome to everybody. I think my sharing has just dropped off, so give me 2 seconds and I'll just bring that back up. There we go. So we've got the tech working. Thank you for the introduction, Jessica, and thank everybody else for your time in attending the webinar this morning. So we have got a fair amount to cover. There have been quite some significant changes from a busy government, so I will box on ahead. As Jessica has said, I'm Myriam Mitchell. I'm based here in Hastings, a partner at Ashcroft Mitchell McGregor. I started life off as a lawyer back in Auckland for 2 firms, Fortune Manning and Duncan Cottrell, did the big law firm experience piece, and then took the move to come down here to Hawke's Bay to set up with Christy McGregor and Kate Ashcroft, who are both in Auckland and Tauranga, a specialised employment firm. So we bring our larger Auckland experience to the regions and have really, really enjoyed working in that manner. So that's a little bit about us. We do employment law, employment agreements and policies and procedures, setting things up correctly from the start, disciplinary and performance management processes, and working through with employers to ensure processes are fair and reasonable, restructuring redundancy, health and safety and privacy, and of course too, with regard to employment law, comes with dealing with PGs and attending mediations, Employment Relations Authority and employment court matters. So if it's workplace related, then we can assist you with relation to that. So what am I going to talk about today? I will talk about some legislation changes, KiwiSaver contribution changes, what's new in the Employment Relations Amendment Act that we saw come into force in February. Then I will talk about what is still proposed and on the horizon for the remainder of the year. A quick recap around some changes that we already saw come in last year, and what else might be some other contemplated changes. So that will be the format for today. So jumping straight into what's new then at the beginning of this year or coming up. First off, in relation to KiwiSaver, hopefully you're all aware that as of the 1st of April, which is real soon now, Can't believe the year is going so fast. The employer contribution rate for both the employees and employers will rise from 3% to 3.5%. That new rate will be applied to all paydays from the 1st of April. And so even if your pay period covers some time before the 1st of April, the whole contribution for that period will be deducted at that new rate. Employees can apply for a rate reduction for a 3 to 12-month period. And if that happens, then an employer can also choose whether to match the temporary rate reduction or whether they remain at that whole 3.5%. And there will be further increases in a staggered approach from 3.5% to 4% leading up to April 2028. So that's just something to be aware of. Payroll automatically do these things, so it is one of those things that just rolls over. But a few key provisions, I guess, to keep an eye out there is if you are paying people by total remuneration and or salaries, then to ensure that by the time those deductions are made, that people are still being paid at least minimum wage for each and every hour worked. So there are some situations where you might, particularly where people are paid at that minimum wage rate, might just need to review pay at the same time as having these new increases take effect. What else is new? This is the real nitty-gritty. Some quite key changes came into force as of the 21st of February this year. We've seen a new contractor gateway test, which I will go through with you. There are some there have been some changes to the rules on remedies and when people raise personal grievances. There's this now new threshold for high earners in limiting their ability to bring unjustified dismissal claims. And in respect of unionised employers, there is the end of the 30-day rule. So that's a summary of the key changes. There's a couple of additional ones as well, which I will cover off at the end. So the really big one is this contractor gateway test. I feel like this will give some good clarity to businesses who engage both contractors and employees. And it really is designed to limit the opportunities for employees to challenge their contractor status. So you will have heard over the last couple of years a lot in the media around the Uber cases. There have been some similar cases in the courier logistics space where people have signed up to contractor agreements, and then they've later challenged their status as a contractor and sought to be classified as an employee, which then gives them access rights to personal grievance claims, holiday pay, being paid retrospectively, all those kinds of things. So it's been an area of significant uncertainty for businesses, and they've had to, in the past, particularly in some industries, manage very closely how they engage those contractors and work closely with those contractors to mitigate risks of their contractor status being challenged. So now we have the government's fix in relation to this, and essentially what the government is saying to us is, look, if you meet these key requirements of being a contractor, then by law you'll be deemed to be a contractor and you won't have rights to challenge your contractor status and seek to be an employee later down the road. What are those requirements? Well, the first is that you'll need to have a written contract agreement that specifically states that the person working for you is an independent contractor and not an employee. That contractor should not be restricted for taking on other work from other people. Obviously, in the moment when they're working for you, they won't be able to also perform work for someone else, but you'll generally need to allow contractors to also take on business from elsewhere. You'll also need to do one of two things. The first is either allow some flexibility in terms of the hours of work, i.e. you won't be able to say when or where they perform that work, or if you can't provide that flexibility, and it's a key term of the contract to have the contractor perform the work at specific hours, then you're going to need to allow the contractor to subcontract the work, and you'll only have limited ability to vet that subcontractor, and that relates to as and when you need to for relevant statutory requirements, qualifications, or criminal records, if that's justified by the nature of the work. So, for example, in the education area, if people are working with children, they'll need to meet the usual police vetting and other statutory requirements in respect of that. And so you'll be able to vet for that, but not more broadly if it doesn't relate to the nature of the work. The next requirement is that the agreement, the principal won't be able to terminate the agreement for any refusal by the contractor to take on additional work other than what is already agreed upon within the agreement. And lastly, the contractor has had reasonable opportunity to seek independent advice before entering into that arrangement. So what's going to be really key here is making sure that you have got really robust contractor agreements that deal specifically with each of these requirements, and review your documentation to ensure they are watertight, that your operational practices align with the test, and also ensure that you're providing draft agreements to your contractors well in advance of the need to sign up to that contract, so they've got that opportunity to give legal advice. And so, your contractor agreements will need to be quite specific. For example, in relation to the second to last bullet point that we've got on the slide here, you'll really want to set out quite a comprehensive list of the work that your contractor is needing to do for you, so that you don't fall foul of the provision of the contractor being able to refuse to do any work for you in a particular area. So that is a key update, a great opportunity for businesses to minimise some of their uncertainty within their businesses, but the contracts are going to need to be watertight, and if you haven't had your agreements reviewed or new ones drafted post this legislation, then I would recommend that you reach out to your usual provider to do that, or feel free to touch base with us and we can give you some assistance in that area as well. So the next key change has been in relation to personal grievances, and the Employment Relations Amendment Act in particular has created some quite key amendments to the remedies that are available to employees when they raise a personal grievance. And so the new rules state that a personal grievance that is brought in a situation where the employee contributed to the situation that gave rise to the personal grievance and that action amounted to serious misconduct, in those situations, an employee will not be able to seek any remedies in relation to their personal grievance. So that includes lost wages, reinstatement, compensation, your other benefits section. All of those are out, and an employee can't seek those if they contributed to the situation that gave rise to the personal grievance and that action amounted to serious misconduct. Otherwise, if there's no serious misconduct but the employee contributed to the situation nevertheless, then there is a restriction on the types of remedies that an employee can seek. They won't be able to seek reinstatement. They won't be able to seek compensation for humiliation or loss of any benefit. They will be able to seek compensation for lost wages if they're successful on their claim, of course. But again, there can be a reduction on that for their contributing behaviour. So essentially some bigger restrictions here for employers in situations where employees have contributed to the situation. And I think this will be music to the ears of most businesses. And I mean, time and time again, when we go through a disciplinary or a PG process, and the comment to us from employers is, but what about the PG that I can raise against employees? Which really to me is just signalling that employers are wanting to understand, well, what's the employee's accountability for this situation when they contributed to that, and that there's now a mechanism for bringing that accountability into place. So, of course, this strengthens what's really, really going to be important is if you review your disciplinary policies and procedures and employment agreements and really strengthen up the definitions of serious misconduct. We quite often see employment agreements that have been drafted and they have a very short list in terms of what amounts to serious misconduct. And of course, here, the courts take an approach of, well, we need to assess what is serious misconduct and what is not serious misconduct. And there's a bunch of case law on that. But essentially, if the parties have contracted that a particular action is serious misconduct in their employment agreements, well, then that is serious misconduct in the employment agreement. The employees had an opportunity to get legal advice on that. They've signed it up. So that is serious misconduct. So I highly recommend that. This is a great opportunity for people to be reviewing their employment agreements and ensuring they have a nice long list of what amounts to serious misconduct and that it's comprehensive. You, of course, won't be able to take conduct that would ordinarily be misconduct and just call it serious misconduct because you want to in the employment agreement, but you'd be surprised as to how comprehensive you can legitimately make that list of serious misconduct. And again, if you need assistance with that, feel free to reach out to us. Also, good idea to be keeping detailed records of the employee conduct and disciplinary process so that you've got proof of that contributory conduct on behalf of the employee. So if you do get to the PG space, you're well placed to defend that. So next key change is a change in the threshold for being able to bring a personal grievance at all for a dismissal. And so essentially the new law is now saying to those employees that earn $200,000 or more in terms of their base income, those employees won't be able to bring a personal grievance for an unjustified dismissal. And that includes where the employer hasn't had the process correct or the substantive justification isn't on point. So there's this ability then to part ways with a senior employee in a much easier fashion than we ever had, and recognition that, we need to have that great working relationship and trust and confidence in senior employees, and when it's not working well, it might, be the need to do something about that. So what about existing employees, you might ask? Well, there's a 12-month transition period to allow current high-income employees to renegotiate their employment agreements and to opt back into the existing unjustified dismissal regime or agree on alternative dismissal procedures or notice periods. So in a nutshell, what that means is you take somebody on as a new employee tomorrow, then these provisions would automatically apply. They would not be able to bring a personal grievance in the event of their dismissal if they earn more than $200,000, unless they have negotiated with you to opt back into that regime, or they have negotiated with you in terms of some alternative arrangement. That's the current position with new employees. With your existing employees, for the next year until February next year, they are still able to bring a personal grievance until such time as either February rolls around next year where they are excluded from bringing a PG and fall under this new regime, or you have managed to renegotiate their employment agreement at an earlier time. Now, when you might have heard in the media that when this bill was first proposed, the threshold for a high earner was set at $180,000. At the select committee stage, recommendations were adopted to lift that threshold to $200,000. And what's taken into account in calculating that figure is bonuses, share schemes, etc. So reflecting the reality of modern pay structures, where quite often employees are not just given an outright salary. So the implications are greater flexibility in managing senior exits. Expect more negotiation around individual employment agreements for high earners, particularly where high earners are getting some advice in terms of having their employment agreements reviewed or their terms reviewed at that negotiation stage. Clearly, you need to ensure that your IEAs clearly cover notice periods, redundancy and termination provisions. provisions. And look, what we are expecting is that a lot of high earners, particularly in industries where they know that they have specialist skills and they've got a few options in terms of their jobs and where to go, that they're going to be wanting to push quite high to opt back into this regime and or negotiate alternatives. And we can give advice in those situations where that occurs. And if you need some additional help in those situations, let us know. One of the key things that we're seeing, for example, is employees are saying, well, look, if I can't bring a personal grievance, then at least I want to have some certainty around how and when my employment will end. Longer notice periods, for example, or a no-fault termination clause, those kinds of things. So we can help you navigate those negotiations should you need it. And the last one here in terms of the real key changes are at the end of the 30-day rule. This, of course, only applies to those unionised organisations that have got collective agreements. New employees covered by a collective agreement used to automatically be placed on the collective agreement terms for the first 30 days. And employers were also required to give them a union active choice form. So the employer really had to do a lot there to facilitate connecting that employee in with the collective agreement and within the union. Those two requirements have been removed, but employers still need to tell new hires that a collective agreement exists, give them a copy of it, explain how to contact the union, but there's just no automatic coverage for that first month. So employers, in terms of implications, will need to be aware that they'll need to update their onboarding processes and expect unions in the next round of bargaining to push for similar protections. So they're going to really want to bring back some of the power that they lost within the legislation and have that covered by their collective agreement instead. Couple of other changes that also came into play with the new legislation on the 21st of February include expanded trial period protections for employees. So you'll all be aware that if you have a valid trial period within your employment agreement and you dismiss an employee pursuant to that trial period, then an employee in the past has not been able to bring an unjustified dismissal claim in respect of their termination under the trial period, and that's now been expanded to also include unjustified disadvantage claims relating to the dismissal. So there's just some greater protections there in terms of challenges for dismissals under a trial period. And the last change is clarifying the test of justification under Section 103A of the Employment Relations Act. We've had this long-standing approach where an employer's actions will be assessed as whether they were what a fair and reasonable employer could have done in this situation. There's a bunch of procedural requirements within Section 103A that need to be met, and the law has traditionally said, well, an employer needs to ensure that they have a substantive justification and the correct procedurally fair process when doing any formal processes with employees, like performance management processes, redundancy, dismissals, serious disciplinary processes, those kinds of things. The new law now says, well, the dismissal or action won't be judged and won't be found to be unjustifiable just because there may have been some procedural errors in the process by the employer, provided they did not result in the employee being treated unfairly. Now, we've always had this provision. It's just been tweaked in terms of how the wording is presented, and it's been strengthened a little bit. And additionally, what's the real new piece is that any obstruction by the or any obstruction to the employer's process by the employee can now weigh against the employees. So where an employee, for example, won't engage, where they keep putting off meetings, where they play all those games to try and drag out a process, that could now weigh against an employee in their ability to bring a personal grievance claim. So that wraps up all of the changes that we saw being introduced in February. Jessica, do we have any questions on those before we move on to the next topic, or would anyone like to put their hand up and chime in at this point?
Nothing in the chat. Does anybody have any questions?
Making life very easy this morning.
If anything comes up, put it in the chat. We can always look at it towards the end.
This is your opportunity, guys. So it is a one and chance to have this discussion, maybe bounce things off each other. I know that probably if you're thinking about a question, other people are probably thinking the same question too. So be brave and chime up. All right, and we'll move on in the meantime, but feel free to pop those on the chat and or just put your hand up. So what's coming next is what we will cover off on these next slides here. So the Employment Leave Bill is very new. It's just been introduced on the 9th of March. And it's been referred to the Education and Workforce Committee on the 12th of March and due to return to Parliament for a second reading on the 13th of July. So this is an opportunity for submissions to be made on the bill. If there is anything in there that isn't clear or you don't think it's workable, now's an opportunity for people to chime up in respect of this. Now, according to the policy statement that accompanied this employment leave bill, the policy statement says that the Holidays Act has created many issues and there's been long-standing concerns for employees, employers and payroll providers, and there really is no mystery around that. I think anyone that's ever had anything to do with the Holidays Act finds it a complete nightmare, and there have been multiple larger organisations who have been caught up in needing to recalculate holiday pay back for many years and having to reimburse employees with respect to that. And the most well-known and publicised incident of that will be the DHBs, which you may have heard about in the newspaper. So it's been well overdue in terms of rewriting the Holidays Act. One of the biggest challenges has been that, you know, especially post-COVID, there has been a big shift in the way that a lot of industries has structured work. We've got the 9-day fortnight, we've got employees who increasingly seeking out flexibility in terms of their work or part-time hours. And save for industries like manufacturing, where they really need a hands-on approach, there's been a lot of varying ways that work has been structured. And so trying to find a bill that meets all situations has been incredibly difficult, and we've had over the years a number of workforces comment on the Holidays Act and some solutions there, and we now have finally a concrete structure that has been introduced to Parliament, and personally it would be really interesting to see how that comes in terms of its final shape and form. But what we will cover off today is a heads up around some of the key changes that are proposed. The key thing to note with that, of course, is it's a bill only at this point in time, and it hasn't been passed. And so once it actually is passed, there may actually be some changes between what is proposed currently and how it's passed. And of course, we will be available for updates later in the year to send out information around what that new regime actually looks like. But in the meantime, here's a heads up as to what might come. It's also been flagged within the bill that there will be a 2-year transition period to allow time to adapt to the new regime, which I think will be important because given the current complexity of payroll and the systems and the software updates will need to be made by providers in the space of payroll. And so I think 2 years will fly by quite quick in that space. So what's proposed? It is proposed that all leave taken under the bill is paid at an hourly rate. So that is a current shift of looking at mostly days in respect of most of the types of leave under the bill. Annual leave will now accrue from an employee's first day of work rather than down the track, and accrues at a minimum rate of 0.5 0.0769 hours per standard hour of work. Annual leave also accrues now during statutory periods of paid statutory leave, parental leave, volunteer leave, and jury service, but it won't in respect of periods of time that people are on ACC, which is quite different to the current situation. At the moment, if people are on ACC, then they are still accruing annual leave, and at the time they take that annual leave, it will need to be paid out at either or the higher of ordinary weekly pay or average weekly earnings, and that regime will no longer apply if this bill is passed in its current form. Annual leave will be recorded in hours and balances not adjusted if the number of standard hours changes. So some key provisions there in terms of what is recommended in terms of changes to annual leave. There will also be changes to sick leave, which again will accrue from the employee's first day of work at a minimum rate of 0.0385 hours per standard hour of work. The proposed cap is sick leave of 160 hours. And so again, you can really see this shift from talking about days to bring everything down to an hourly rate. At present, there is a cap of sick leave of 20 days by way of comparison, and under the new legislation, it will be 160 hours. And again, sick leave will be able to be taken in hours. Now, practically, what does that mean? Probably not a lot for a lot of employers. I haven't really met in all the time that I've been an employment lawyer too many situations where employers have sought to restrict employees from being able to take a part day of sick leave, so they've got to go to a doctor's appointment or only have half a day off for sick leave. They come to work in the morning and then by lunchtime they're really not feeling well and need to go home. And the majority of employers I know have sort of been recording in hours and or part days anyway, and so just really standardizing everything. However, bereavement leave and family violence leave will remain day-based entitlements, but they'll also arise from the employee's first day of employment, and employees may be able to take part days for those entitlements. Again, something that most employers have already generously been allowing employees to do, but from if this new bill is enacted, that will be a requirement for employers to allow that. There will be also some changes in respect to how leave is dealt with for casual employees. So there'll be a new casual leave payment plan that will be introduced, and payment will be set at 12.5% of an employee's ordinary hourly rate, and it's paid additional to on-call hours worked. So that's instead of accruing annual leave and sick leave, though, again, practically speaking, not a lot of casual employment situations I know do employers have annual leave accrue for casual employees. They'll normally pay that as you go, but of course sick leave you haven't in the past been able to pay that as you go, but it looks like that's what the new bill is proposing. There is also some proposed changes that will apply where those employees have got a variable schedule. So introduction of new rules around what is an otherwise working day test for public holidays for employees who don't have fixed days of work in their employment agreement. Under this test, a day is treated as an otherwise working day if the employee has worked or was on paid or unpaid leave for 50% or more of the same day of the week as the public holiday in the preceding 13 weeks. So it just gives some clarity around how do you calculate an otherwise working day. So that is what is proposed in terms of changes to the Holidays Act, and what the final changes will be and what the final act actually looks like. We will have to wait and see, but we'll keep you posted. Okay, so what else is on the horizon then? There's a bunch of other things that the governments are still working on, and I know that there's been a lot of side distraction in terms of what Parliament has had to turn its mind to recently, with and particularly in relation to the war in Iran. But a ticking time bomb behind that in respect of the election that is coming up later this year, and there will be, I'm picking, a real drive by the government to be wanting to pull over the line some of these other provisions that they have been working on for some time. So let's have a talk about those. The first being the Employment Relations Termination of Employment by Agreement Amendment Bill. This is at its second reading phase. The Select Committee reported back to Parliament on the 9th of April, then it'll go to second reading, quite often to a third reading before this is actually passed. So still in progress, but at this point in time, what is being proposed is that, again, the law will be changed to allow employers and employees to have exit negotiations. These will be called pre-termination exit negotiations, with protection of secrecy and no right to personal grievances in respect of those negotiations. So it's much the same as the current regime, where employees and employers get in a situation to have a without prejudice or off the record discussion, except that currently there is risk for employers to propose a without prejudice conversation, particularly when there isn't already an employment relationship on foot. Whereas under this new regime, employers won't need to prove that there's an employment relationship problem on foot. They just will be able to propose such a discussion with an employee. There are some parameters around that. So, for example, the employer, any request by the employer must be accompanied by information to the employee of the right to have representation, allow the employee to have a reasonable opportunity for that, and that needs to be a real opportunity. So, for example, proposing to an employee that you have with one of these pre-termination exit negotiations, but saying to the employee, come back to me by tomorrow, is not going to cut the mustard in terms of allowing a reasonable opportunity to get representation and advice in respect to that conversation. Employers will have to tell employees that they can decline the request, and also a request can not be made more than once in 6 months unless there's a genuine reason based on reasonable grounds. We don't yet have insight as to what that means, but that'll be fact situation, and it'll be sort of really dependent on the facts and dependent on the situation at hand at the time. And so if this bill is passed as proposed, there'll be this opportunity for employers to just be able to have those direct conversations with employees. Of course, though, if you enter into them, you can bet your boots that employees are going to want some form of exit package in exchange for that exit, right? You'll still be able to ask for a record of settlement in respect of that exit package to ensure that you're shutting down any otherwise PG rights. Otherwise, I would urge you to look very carefully at the situation, because if you've got genuine grounds to exit an employee anyway, for example, it's a clear case of serious misconduct, yes, one of these pathways may cut to the chase, but there may be situations where you're best placed to rely on the formal process and be done with it, particularly now that employees can't seek remedies for PG claims where they actually have committed serious misconduct. So why would you get yourself in an exit situation negotiation when you've got a formal process to exit the employee with probably less cost in any event? So they'll need to weigh up strategically what's best, what are the reasons. Do you have a fallback process? How foolproof is the justification behind that? All of those same considerations that apply currently before considering whether you go into mediation or exit negotiations with an employee. What else about this? Allowing employer employment exit negotiations, a few other points to note about that. Negotiations won't be able to happen without the employee's agreement. And of course, that's obvious from this requirement here to inform employees that they can decline the request. Neither party can engage in misleading or deceptive conduct through the negotiations. Employment can end due to a termination agreement. The employee will be entitled to seek advice on that agreement. The termination agreement will be a full and final settlement, and evidence of those negotiations can't be brought in evidence before the authority in a personal grievance, of course, unless it's to challenge the legitimacy of this process. So, for example, if an employee wanted to say, you know what, my employer came to me more than once in 6 months, that type of evidence, of course, will be able to be brought in a challenge. The bill defines unfair negotiations where the employer is aware that the employee does not have capacity. They relied on the employer advice and didn't have, for example, have an opportunity to get their own, or they were induced to enter that termination agreement by oppressive means, undue influence, or duress. So implications for this is we urge employers to set their strategy for addressing concerns with an employee before setting down this path, and be sure to make sure that employees are engaging, because if they don't, you kind of want to know what's the what next. So, for example, you go down the process of seeking to have one of these conversations with the employee. The employee pushes back and says, nah, I refuse to engage. Well, then you're going to need to have a fallback position, and that might be your performance management or disciplinary process. And so it's good to sit back and think, well, what's the overall strategy from the outset, so that you've got some contingencies in place. And again, if there are situations where you're needing some strategy advice around that, happy to help. Right, so that is what is potentially on still on the horizon for the remainder of the year. And we will do a quick recap of what already came into play last year. So we had the Employment Relations Employee Remuneration Disclosure Amendment Act that essentially now allows employees to go and talk to other employees if they want to disclose what pay they are on. They're allowed to disclose that to other people, and there can be no repercussions for that disclosure. Of course, that disclosure is voluntary. It sits with that employee. It's their information. If somebody else asks, they don't have to share it. They do share it. There's not a lot the employer or anything that the employer can do about that. There were some Parental Leave and Employment Protection Amendment Acts changes around that had some changes in relation to employment leave provisions. So, for example, the changes clarified that certain absences from work will still count as hours worked when assessing whether an employer or a self-employed person meets the required work hours to qualify for parental leave payments. Also clarified that any week for which preterm baby payments are made are in addition to and must be counted as part of the maximum period of primary care leave and the maximum period of extended leave or the duration of the parental leave payment. Also clarified that a person who is a primary carer but not the birth mother or their spouse or partner, for example, through adoption, surrogacy, or wangai, is entitled to parental leave payment if the person stops working as an eligible employee or an eligible self-employed person within a reasonable period after becoming the primary carer. So some key changes around that. We also saw last year the Crimes Theft by Employer Amendment Act being passed. In a nutshell, that criminalises the failure to pay any money owed in relation to employment, under the agreement or the Employment Relations Act. So that if you are intentionally withholding that from the employee and you know it's due and the employee's, asking for it and you're just declining to provide that, then that could be considered theft and a crime under the Crimes Act. There have also been some changes to equal pay, and a Equal Pay Amendment Act was introduced, with a new framework really to ensure that parties can more confidently assess whether there is a sex-based undervaluation in the pay of female-dominated work. And there was a lot in the media at that time because it sort of stifled where progress was at that time. But the intent of the regime was to create some more framework around that. And we also saw an introduction of IPP3A, which is a brand new privacy principle under the Privacy Act. So for those of you that are familiar with the Privacy Act, it had always from the start contained information privacy principle number 3, which requires agencies, which are businesses or organisations, to inform people when they collect their personal information from them. Now, under IPP3A, if you're an organisation and you're collecting information about an individual, but you're not getting it directly from that individual, but you're getting it from another organisation over here, then you need to tell that individual that you're collecting that information, unless one of their standard exceptions within the Act apply. So that's just a little newbie to be aware of there. So that's what we saw come in play last year. And then I just want to finish this session off by giving you a heads up about some other potential changes that are coming on the horizon as well, if the government's able to get these over the line by election time. They are proposing some changes to the Human Rights Act, for example. So there's currently a members' bill that is consulting on the extension of prohibited grounds for discrimination in terms of gender identity or variations of sex characteristics. The bill was introduced on the 3rd of August last year, has made very limited progress since then, as it still hasn't had its first reading, but there is that bill sitting there. There is another bill sitting in Parliament currently that proposes some changes around the ability to use restraints of trade. So this bill proposes to prohibit the use of restraints of trade in employment agreements for lower to middle income employees. And the legislation, well, not the legislation, the proposed legislation sets this limit at 3 times whatever the relevant minimum wage is at the time. Restraint of trade clauses for higher income earners could also be ineffectual unless reasonable compensation has been paid to the employee in respect of that. So it's going to, again, you can see, right, if this is going to be introduced, if you have higher income earners, you're going to need to have a really watertight employment agreement. And I would suggest have separate compensation stated within that employment agreement for the restraint of trade, as opposed to just having it all wrapped up in one salary package. Compensation would have to be separate from any salary or wages, as I've just said, and connected to the employment and amount no less than half the average weekly earnings of the employee for each week that the restraint of trade would apply. So again, setting the strategy in terms of how are we going to structure the pay for these higher earners. Will part of that will need to be separated out and be allocated to appearing to be compensation for these restraints of trade. And we have come, I think this is the last slide, so we're coming to the end. Some other changes that the government have flagged are around modern slavery. We have a bill that seeks to introduce a new reporting regime to address incidences of modern slavery and the effects in New Zealand. Who is required to report under the Act? Well, all entities with a consolidated revenue over 100 million, and this includes not just New Zealand entities, but also overseas companies that carry out business in New Zealand. So it'll be quite far-reaching in respect of that, but limited to the larger organisations. Why? I'm not sure, because probably from our experience in the cases that we've had with regard to, for example, the labour inspector, the issues in terms of modern slavery really appear probably more in those middle sector, sometimes lower, as opposed to the larger. But that is what is proposed at the moment. Entities covered by the regime will be required to produce an additional section to their annual reports, and they'll need to cover things like a description of the operation, structure and supply chains of the reporting entity, a register of modern slavery incidences that have occurred in these processes and how these incidences were addressed. And then, of course, the bill also contains an extensive enforcement regime, including directors' liability in respect to that. Otherwise you're really just relying on the trust of organisations to report on these things. So that is what are some of the potential further changes that will come later this year, and brings me to the end of our slide and presentation. Jessica, any questions?
No questions in the chat. Wondering if anybody wants to speak up.
Chime up.
And yeah, I mean, pardon me. This is really a great opportunity to get some advice from someone, Myriam, who we don't always get to have her amount of expertise in the room with us. So if anybody wants to share anything that maybe they've even come across in the past year that they want to share an example of an area that they're looking for some advice, or which way sort of to turn to start looking into something that they think might be coming up for them or areas of concern. Oh, thank you, Julie. She just says Julie has to go, but she's saying thank you for the
Great.
presentation. Yeah.
Thank you, Julie, for coming today.
Yeah. I think, something that came up for me just when you were going through your presentation, that it's not really a question from me, but we recently had an event with Family VIP Services, who was previously Hastings and Napier Women's Refuge, and they did a really great presentation and talked a little bit about the family violence leave, and some information around that. It was really, really helpful. So just wanted to put them out there as a resource as well, if you're looking for any information, particularly around that, how to support your staff that might be facing family violence. Family VIP Services is a really great resource for them as well, for that
Absolutely.
situation. Yeah.
Yeah. I have worked with Family VIP Services, and they provide a fantastic service, and really great to have some sort of structured support around that. The Family Violence Act and the leave provisions themselves don't provide a lot of guidance in terms of how to actually apply the leave. It's simple things like what information people need to give to their employer at the time that they are seeking this leave. Those kinds of things are left quite loose within the legislation, and it's certainly helpful to be talking to people like Family VIP to get some insight in respect to that, because it's difficult, right, for employees and those types of situations to be thinking structurally, well, what do I need to do and give to my employer? Because rightfully so, their focus is elsewhere in those situations. But the other tip I would have around that is to set some parameters within your employment agreements upfront, so that employees know some basics around the type of evidence or information that they'll be asked for by the employer in those situations, notice periods and those kinds of things. So you are able to set some rules and address this through your own sort of customised clauses in your employment agreements up front as well, and that can be helpful so that employees, they're aware of what the expectations are, and that helps manage that relationship.
Yeah, and one thing that I found really interesting that they talked about was the fact that you could take leave for family violence, and the violence actually might have occurred years ago. But if you're suffering from maybe some residual problems with that, whether it's trying to get your kid into a new school, or you're experiencing maybe some PTSD from it years later, that that Leave Act still applies, which was really interesting to me. I think question that I had was when it comes to employees who have, oh, we have a question in the chat, which I'd rather do
Okay.
than my question. If employees need EAP, are employers obligated to provide it?
Yeah, good question then. This is one of those areas where really there's a lot of intersections between employment law and your health and safety obligations. It's best practice always to provide EAP. Is the default position, but whether there's an obligation to provide it really depends on what stems the need for that EAP. And so if it is because the employee has a lot of challenges at the moment in terms of what's happening in their personal space, but that's making it difficult in terms of how they show up for work, because we bring our whole people to work, right? Then you don't have a lawful obligation, a legal obligation to provide that EAP. If, however, there have been situations at work that have affected the mental well-being of people, then you have a bunch of obligations. And the employer's obligation, as we know, under the Health and Safety at Work Act, is to ensure the health and safety of individuals at work and to take all practically reasonable steps to look after the health and safety of people at work. And the definition of health within the Health and Safety at Work Act specifically says mental health and physical safety. And so we do, and it's not so well known, have this positive legal obligation to ensure the mental health of our people at work. And we've got this obligation to ensure that what's happening in the workplace is not affecting the mental health. So in the same ways, you can't run your business in a way that would cause an injury to people. You can't run your business in a way that would cause a mental health injury to people. And that could come in all shapes and forms. It might be ensuring that you take some steps around bullying, around ensuring that you've got a correct match of the skills and experience of people in the work they're doing, because if that's not right, then people will be stressed at work. It might be a fatigue related issue. And so it's quite broad, but the basic answer is then if you've got these workplace factors that are causing harm to your employees, then you've got not just obligations to provide support, and EAP is the easiest, but you also then need to identify what those factors are and put in place some control measures in respect of those. That's another whole topic that I've presented on at length for the Chamber, right, Jessica, in the past. Yeah.
Yeah.
But that's the short summary of it.
Yeah, thank you. Thank you for your question as well. Oh, so the question that I was going to ask was, and maybe this is just my privilege and being lucky not having to deal with dismissals, is when you were talking about employees who have contributed to the situation that has led to a dismissal process. Like, do you have any examples around that? Because that to me, that's just a completely new, something I've never had to deal with before. So I was really struggling to kind of imagine in my mind what those situations might be.
Yeah, absolutely. And it's a really interesting question. As with most things, when a piece of law seeks to bring some clarity or simplification for an employer, normally it opens up an opportunity for arguments to be had elsewhere. So now we have this new piece of legislation that says if an employee contributed this to the situation and/or they committed serious misconduct, then they don't get these remedies. It sounds simple in principle, but however, we also have the realities of employees will be wanting to keep their jobs. Some employees will go to employment advocates who, as we know, are able to create some pretty creative and constructive arguments in these types of situations. So what we're picking is that there'll be more debate about what is serious misconduct, what's not, because an employee obviously will be wanting to push back on having something called serious misconduct. again, which is why we're saying really important to shore that up as much as you can in your employment agreements from the start. And then again, it'll be a question of, did the employee contribute or not? What was the actual causative factor behind that? These are the types of arguments that we're well versed having in the legal field, and the Employment Relations Authority we'll be able to make decisions on as new cases unfold under this. But there will, as with anything, be situations where 100% we know the employee contributed to it. It's a clear-cut case. There'll be other situations where it's absolutely clear the employee didn't contribute to the situation. So, for example, a redundancy. They don't contribute to the redundancy generally, and a genuine redundancy is all about whether the employer needs that role or not. It isn't about the employee themselves. So if the employer doesn't get a restructure process and a resulting redundancy correct, they don't have, for example, a genuine business reason for the redundancy, or they haven't followed a fair process in respect of the employees, then the employee will still be able to bring an unjustified dismissal, personal grievance with respect to that alleged unjustified redundancy, and be able to get the whole suite of remedies. That would be one situation. I can imagine where the Employment Relations Authority or court would say, nah, no contribution, and so still access to the full suite of remedies. Others in this extreme end will be where the employee has obviously committed serious misconduct, and there'll be some situations where that's really clear. They're caught stealing on like CCTV, they've got their hand in the till. There are some situations of serious misconduct where the employer's got some quite clear evidence that is what the employee did, and so they will have contributed to the situation that gave rise to the dismissal. Serious misconduct, repeat instances of misconduct, those kinds of things. And then there'll be other ones where, and this is nothing new, employers are sitting there as they go through the disciplinary process and thinking, oh, do I dismiss in this situation or do I not? Is it serious misconduct or do I not? And there's always those grey areas where it's not clear whether there was serious misconduct, and some employers will just box on ahead and have decided by then, particularly if the employee hasn't engaged in that process very well, they're done. They want that person gone. And then there'll be a battle afterwards as to the extent to which remedies should be reduced for that contribution. Does that answer your question?
Yeah, that's helpful. Thank you. We'd have a hand up from Chris and Matt, if you want to unmute yourself and ask your question.
Yep. Hey, Myriam. I've got a question on the leave rate accrual and how that can affect annual leave. I'll try and explain my question as best I can. So people at the moment, they get their 4 weeks leave a year based on a 40-hour week. With that, if they're going to be working, say, between 45 to 50 hours per week on average, and at that new rate of accrual, they'll accrue more leave. But in the past, with doing those hours when they took their leave, their wage rate would be paid out at that higher rate based off the 40 hours, if you understand what I mean by that question.
Yeah, absolutely. And so what Matt is saying, look, in the past, if somebody has had some weeks where they've worked more than others and they've been paid more for those weeks, unless they're on a salary, that feeds into at the time that they take the leave, they still only get 4 weeks of leave, but at the time they take that leave, it's the higher of ordinary weekly pay, which is the amount of pay that's stated by the employment agreement, or their average weekly earnings. And so, if people have had bonuses, if they've had significant periods of time where they've worked more, obviously their average weekly earnings will be higher. That's the rate at which they get paid out that annual leave. And now what it looks like is being proposed is that your annual leave will accrue at a percentage based on each and every hour worked. And so it looks like you'll get more leave as opposed to getting paid more for the same leave. I don't have 100% clarity on that in terms of what the bill is proposing there and whether it's a cap, but yes, it looks like that is the resulting situation.
So that if they, I mean, you may not know yet, but so if they take leave in future, let's just say they end up with an average of 45 hours a week annual leave, would they just get paid at their normal hourly rate moving forward at that point, or at what the average pay rate had been? Is that
It's a
unknown?
very good question, and one that I would need to delve further into in terms of the legislation to understand what the mechanism is for the proposed mechanism for that. And certainly something that we can update on as the bill becomes clearer.
Thank you.
Any other
other
questions?
Yeah, any other?
Otherwise, we're on time and we can wrap
Yeah, it's
up.
great. Yeah,
Yeah.
wonderful. Thank you so much, Myriam. Really appreciate you taking the time to deliver this webinar for us. Really helpful information. Just a reminder to everyone that we've recorded this and it is going to be available for rewatch on the Chamber website. So you can always revisit some of those areas that you want to have a second look at. And then also please feel free, once that is posted, to send it to anyone else who you think might benefit from watching it. We're looking at doing more of these webinars and recording them and having them available on the Chamber website. So if there's any topics that you think would be helpful, or if there's anybody out there that you think has knowledge that would be beneficial for the business community, please do get in touch with me, and we'll look at doing another one with them. Myriam, is there anything that you want to sign off with?
Yeah, I just wanted to say, look, I've put my email address in the chat here. It's simply myriam@ammlaw.co.nz. So if you had any other questions that you wanted to follow up with after this, feel free to touch base with us. Matt, if you wanted to drop me a line, for example, I'm happy just to have a quick look at whether there is that clarifying information in the leave bill at this point in time to sort of give some more certainty to your question. If you wanted to drop me a line, feel free, go for it. Otherwise, thank you very much for taking your time out of your day today to attend. And I hope that you will have a fabulous rest of the week.
Great. Thank you very much. Thanks so much for attending, everyone.
Yeah.
Hope to see you at the next one.
Bye.